Thank you and welcome to our program tonight. My name is Carrie Ann Crawford and I'm from the Administrative Judicial Institute at Oath here in New York City. And the Institute is a resource center that provides training and continuing legal education for the various administrative law judges and tribunals throughout New York City, though we've kind of expanded our mandate and we're taking over the state. Um, and to that point, we are presenting this program tonight with Albany Law School. We have a great speaker here for you. Before I tell you a little bit more about our speaker, I will pass to Lisa, who will go over some administrative things for us.
Good evening, everyone. I handle all of the CLE for Albany Law School, so you should have gotten in your confirmation email and links to the forms and to the program materials. If you haven't, please send me an email. I will drop it in the chat. Also, I've noticed there's a couple of people that are actually listening on the phone. If you need CLE credit, when you send your forms in, please let me know which phone number that you listened in on so I can find it on our report. I have a requirement that all of the CLE forms be submitted to me within 24 hours of the program in order to receive credit. The CLE forms are fillable PDFs and you should not have any issues completing them. You'll need to download the forms, save them, complete them, save them again, and then you'll be able to attach them to an email to me. All right, back to you, Carrie Ann.
Thank you, Lisa. So tonight's program is called Emerging Digital Evidence and Admissibility Issues. Our speaker is Professor Michael Hutter. He is a senior member of the Albany Law School faculty. Professor Hutter's bio was included in the written material, so I won't go through his entire bio. I will say that he is currently teaching, or his teaching areas include evidence, New York practice, federal jurisdiction and procedure, conflict of laws, business torts, and trade regulation. We're very excited about having Professor Hutter speak to our group tonight. We're looking forward to a great presentation. Please feel free to put your questions in the chat. We will be monitoring the chat, so questions, comments, put them there. And I know in the past some people have had trouble hearing, and if that's the case, there's the closed caption button at the bottom of your screen. It says CC inside of a little rectangle, kind of towards the bottom middle of your screen. So if you're having any trouble hearing, feel free to just click that, and it will show a closed caption report of what's being said. And with that, I will pass it on to you, Professor.
Thank you, Carrie Ann. Good evening, and welcome to the admissibility of digital evidence. Some basics, emerging trends, what's going on. Now, obviously, as you know, I'm not going to date myself, but when I learned evidence and when I practiced trial work, and when you learned evidence, probably everything was paper. Letters were being offered into evidence, business records in paper form being admitted into evidence. Now everything is electronic, digital, and it's taken over now, and it's created not necessarily new issues. We're going to be using the same evidence rules, just looking at them a little bit differently. And it's that transition that starts to become not necessarily difficult, but to make it smooth, to be alert to some of the lurking issues. And all that's a result of the ability now of hackers to create false websites, create false emails, do everything, fraud on big, large scale. And courts have to become aware of that. Now, interestingly, back in the 90s, a federal judge down in Texas made the statement when emails were being offered into evidence for him. The judge said, "No, not in my courtroom. None of that voodoo evidence. I don't trust it one bit." And now 20 years later, he's still on the bench and he admits now he's eating crow. Now I realize that I spoke too quickly, and I now realize that there really is very little paper evidence anymore. So what we're going to be doing is looking at, and the way my materials are organized. looking at the basic forms of digital evidence that will be presented before you, and whether or not the attorneys have laid the proper foundation for you, and for you to understand what would be a proper foundation. Now, we'll be looking at, in that regard, the way I have it set up, the basic digital formats, social media posts, the profile page of someone's Facebook, the emails, text messages. Now we see a lot of Facebook messaging. Then we see website data, whether it's a government website or private enterprise website. And then we'll be looking at some issues involving computer records, records that are created by hand and then are stored and printed out in electronic form and digital form. And then as well, computer records which are generated by computers. Your ATM receipt, for example, your Easy Pass receipt, or your bill every month. So we're going to look at the basics of that. We'll then be looking at a little bit more with time permits, judicial notice, or what's called in the administrative realm, official notice, where you can take official notice from certain websites, and instead of now requiring it to be proven to certain information. Now, the good news is that the same evidence rules that you used when you were in practice, when you learn evidence, are the same ones that govern digital evidence. There is no new set of rules specifically geared to digital evidence. It's just applying the traditional rules in a new medium. And I recognize, obviously, that in administrative hearings, the rules of evidence are not required to be followed. Hearsay is admissible, but you have to only allow in relevant evidence, got to follow privilege. Now, that's true, but what I am seeing now, in my experience as an ALJ, I've done some hearings for the Commission on Judicial Conduct, where a lot of digital evidence is being offered. I'm very much aware of the possibility of fraud. So I require the attorneys to, as much as they can, follow the rules of evidence to ensure reliability. So my idea now, what I'm going to be telling you, is that follow the rules. You're not going to go wrong. You'll never be reversed. Your findings of fact, your decisions will be upheld. And it's not going to be overly difficult. Now, what I've done with my materials is, at least the first pages 3 to 15, I just gave you a broad overview of the rules of evidence, New York evidence rules, the federal rules of evidence rules, the ones that you learned evidence from. I'm not going to get into that, just there for your review when you have the time. But the rest of the material now, you'll notice if you thumb through, I have citations to New York cases, and as well other states, and as well the federal courts. Now, the reason is that all jurisdictions, all courts, are pretty much following the same rules. If it's admissible in the state of Washington, if it's admissible in the federal district court, Southern District, inevitably it'll be admissible in a New York court. So I'm giving you a wide range of decisions, and a lot of them have been chosen not necessarily to state what the black letter law rule is, but good illustrations for you now to learn and see how other judges have applied these rules. And I also have a smattering of references to some key articles that I think are very good to put in your trial notebook to help you to get through some hurdles. But the one thing I would recommend to you, and there are references throughout the material, I'm not sure how much familiar you are, but there is now published, and it's on the Office of Court Administration website. I'll give you the URL in a minute. The Guide to New York Evidence. It's a project that was created by Chief Judge Janet D. Fiore in 2017. She was concerned that the basic evidence treatises that lawyers applied, judges applied, were now hopelessly out of date. And there needed to be a current version of what New York law is. Now, she recognized that the state legislature will never enact a code. So what she did is she put together a committee composed of present judges, retired judges. I was appointed the reporter. And we now have created and we have stated every evidence rule that the Court of Appeals has recognized. And it's in this Guide to New York Evidence. And you'll see that the organization is fairly close to the federal rules, which you all are familiar with. I'm sure that's the way you learn evidence. And the citation for that is as follows: nycourts.gov/judges in caps /evidence lowercase. nycourts.gov/judges in caps /evidence. And you can also just put in Google Guide to New York Evidence, and you'll come up with that citation and the rules. What I found that a lot of judges, a lot of lawyers, they'll print it out, put it in a binder, or just bookmark it so that they can use when need be. Okay. As I said, I can jump over the initial 15, 16 pages. It's just simply some background information for you to digest when you need it, to refresh your memory of evidence if you need a refresher. But I don't think it's necessary to regurgitate any of that. So I want to start with the material on page 17, looking at the application of the evidence rules to various forms of electronic digital evidence. And I'm going to start with social media posts. The material that you see on someone's Facebook page, the public page. And that public page will probably have a profile. The person will, whoever owns it, and hopefully it's the person's true owner, will put forth some basic information about him or her. And then there'll be some posts that the person has put on there, and maybe others have. We're not talking about private posts that are accessible only to friends. Now, in New York litigation, the Court of Appeals has made it relatively easy to obtain discovery of private posts. And I know that there's limited discovery in ALJ hearings, so you're not going to be involved with that. But anything that's on a public page can be used. There's no privacy. So that's what we're looking at. Getting in the information that's posted on someone's, Michael Hutter's, Facebook page. That there's something there that's relevant. Now, the first order of business that I get into, page 17 into 18, is looking at proving the post and dealing with authentication. That's going to be the major concern for you, is authentication, which is nothing more than a species of relevance. So that's why I think the authentication rules should be your Bible to follow. Now, in that regard, the one thing to keep in mind about dealing with a post that someone's offering to evidence, that post can be proven by the party offering a printout of that page, a copy of it, maybe a screenshot of it. And if no copy has been obtained, even oral evidence of its contents. we'll see that's not going to present a major best evidence rule. But we'll be talking about that as we go along. But keep in mind the format. The format, the first rule of order then, after they have marked it as an exhibit, and now are asking you to admit it, looking for the foundation. I start now on page 18 in a decision that you really should read at one point. This is on page 18, bullet point 2, the United States v. Zahner decision. Decision from the Second Circuit. The defendant was convicted in the Southern District on the basis of a completely fraudulent Facebook page, the Russian version of Facebook. They went to such lengths to set him up by putting this Facebook page in his name, etc. And the trial judge said, well, it's his name on it, let it in. And the Second Circuit really chastised the judge. No. Just because the page has his or her name on it doesn't mean that is his or her page. You have to authenticate. You have to authenticate and show that the Facebook page is the person you claim who owns it. That if it says Mike Hutter, that it is Mike Hutter's actually created page. That's authentication. It's the real thing. Now, the reason what the Second Circuit got exercised about is that the trial judge didn't realize that. And the Second Circuit said it's too much fraud. You got to be careful. So, how do you authenticate? The three basic methods that will be there. They may call the owner. Is that your page? Yup. Fine. Looking at the person's personal computer. You can analyze that. Forensic person, the IT person will come in. I scrutinize the personal computer. I looked at the internet history. I looked at the hard drive. And this is his page. He's working on it from his computer. And then third, you can then, if possible, and this will be only, I think, in rare cases, they'll bring in an ad, maybe ask you to subpoena a Facebook representative who can then go through the network and how that Facebook can now show you that this is Hutter's webpage. But barring those three, what's commonly used is what I mentioned now on page 19. Circumstantial evidence. Now, the common law rules of authenticating, say, a letter, a document, always said that and always held that you have to authenticate, show that it is something written by Mike Hutter. How do you do that? Well, one of the ways that the common law has traditionally recognized is through circumstantial evidence. Evidence that strongly links the page to its claimed owner. Now, I mentioned here on page 19 in bullet point 5, some of the things that lawyers will point out to you. And these are nothing more than traditional common law rules. The Zahner case specifically relied on this. Certainly show that the purported owner had complete exclusive access to that computer. Testimony of a person that I always communicated with that person all the time. The contents, information that only the creator would know, putting posts about what he or she did that night. Only that person would know, and if they're posting about it, strongly shows that's his website. And most importantly, the length of time, especially with a post, or maybe profile information, which is the owner now claims, oh, that's wrong. How long has that been up there? If it's a fraudulent post and a person is monitoring and using his or her website, her social media page constantly, they should be alert to it. So the longer it's on the website, it's undoubtedly the owner's. He would be aware of it.
Okay, Professor Hutter, I'd like
Yes.
to just break in for a moment. Everyone who is looking to obtain CLE credit, here is the first of the two code words. If you can all see that. The first code word is 09 text. That's TEXT. Again, 09 TEXT. Okay, go ahead.
Another way that the type of circumstantial evidence is distinctive characteristics. And it was interesting, on my way home tonight, I was listening to ESPN radio, and the hosts were signing off. And they've been doing that all the time by saying, Arrivederci, see you in the promised land, constantly. And if that's the way a person maybe puts on his website, those distinctive characteristics, that certainly links the person up. Now, it doesn't guarantee authenticity. Remember, with authentication, just something from which you now can trust it. And then let the other side point out that really it is fraudulent. But the prima facie burden is not exceptionally difficult. You do not have to require proof clear and convincing, beyond a reasonable doubt, just preponderance. Now, I also then give you several examples from some federal cases and state cases, which I find to be excellent examples of all this. How the judge involved admitted properly, and sometimes erroneously, using the basic authentication requirements. And I'd especially point out on the bottom of page 20, the Barber decision. Again, it's illustrative of what you need to do. And basically, in many respects, it's common sense. You look at that, you see the indications, and yeah, that links the person up. That's all that has to be done. Now, that's with writings, the profile, legend, posts, written posts. But also now, keep in mind that you can post on Facebook photographs, videos, YouTube videos. How does that work out? If someone is introducing a Facebook page, why? Because that page has a photograph of a party in very questionable circumstances, relevant. And you now want to get that picture in. How do you do it? Well, the Court of Appeals in People v. Price that I mentioned on page 21, which is now being followed by almost all other jurisdictions. When you deal now with trying to get in a photograph, you do not necessarily have to show who owns that website. Your focus should be on the photograph and the basic foundation requirements of photographs. Is that photograph a fair and accurate representation of the person at the time it's purportedly at? And again, you get your foundation witness who can verify that. Yeah, I was at that party. I saw him there. And that's a good picture of him at that night. That's all. You do not have to show the validity of the Facebook page itself. Now, that's important because the Court of Appeals recognized in this case that a lot of times you may have some difficulty with respect to that owner of the page, especially now when that photograph is appearing on someone's web page and you're not necessarily involved with the owner, but they put a picture on my website. And I want to get that post in. So who owns it really is irrelevant. And that's the teaching now of the Price case. Now, the Court of Appeals in a follow-up on page 22, YouTube videos that are posted. Same thing. Foundation witness, maybe the person who recorded it, the videographer, someone who was there watching it, the events being depicted, and say, that's a fair and accurate representation of what I saw, what was going on. All you have to do. Now, obviously, with respect to the YouTube, you do not then have to get into showing, well, how was that recorded? What was the equipment? You don't need to call the videographer. It's just simply just like a photograph. You don't have to call in the photographer, just someone who can say it's a fair and accurate representation. Now, remember, a lot of times with these YouTube, they will have that running legend at the bottom, which will say the time it was being made, the date. That can be authenticating information as well. It's not hearsay. Anything printed on those images is computer generated. As we'll be talking about later, that makes it non-hearsay. So that's the thing to keep in mind now about authentication. Hearsay, you have the same results, same hearsay rules. Nothing more. If it's coming in for the truth, you have to have an exception. Now, ordinarily, if it's a post profile page of the owner, and you've established it's the owner's, it'll come in as an admission. And then remember, as I mentioned on page 23, because a lot of times lawyers overlook this, and they'll make an objection, Your Honor. The hearsay rule with that YouTube photographs do not implicate the hearsay rule because they're machine generated, not human generated. So that's what I mentioned at the top of page 23, citing to the Cameron decision from the District of Maine. Now, best evidence. Let me mention this now, and I don't have to repeat it for the other forms. Remember your best evidence rule. You must produce the original of the writing. We don't want copies. We don't want oral testimony. That has been chock full of a lot of exceptions. If the original has been lost, destroyed in good faith, altered in good faith, you don't have the original, we will permit a copy of it to come in if you have a copy. Or you can use oral testimony to describe what I saw. If you don't now have that web page, that page. But also keep in mind, and again, going into the computer world, in actuality, the best evidence, the original, is the hard drive. The hard drive of the computer. So are you going to require the hard drive to be brought into the courtroom, your hearing room? Of course not. It's gobbledygook. You need to read the printout. So all courts are recognizing now that although the true original is the hard drive, basically when you print out that information, the email, the Facebook page, that copy suffices to establish the best evidence rule. So don't worry about that best evidence rule at all. Again, if you don't have anything, oral testimony, one who saw it will suffice. I have some better cases on that with other forms of digital evidence that I'll be going through.
Professor Hutter, we had a question in the question area. Are there court decisions that provide guidance as to protecting against online images that have been photoshopped? If a proponent only needs to testify, I observed him at the party, that is what he was wearing, but proponent cannot testify that they observed the individual in the pose reflected in the image.
The photoshopping is a problem now, and courts are just starting to address it. And essentially, if you have that photograph and you have that person say that's his face, but now you have that person strapped holding a assault weapon, and that assault weapon now has been photoshopped and put on his body. Now, what you would have to do is the person now would come out, you have to lay the foundation for it. The person would have to say that I saw him that day with that assault weapon. If that's, again, if it's critical, if you really want that photo in because of he's holding an assault weapon. Now, the problem then is, what really creates issues is, what will then happen is, you may not have a person, that person may just simply say that, yeah, I think I remember seeing him with an assault weapon at some time. The problem with photoshopping is you then have to find some link to let that photo in, if there's something that connects that person with that assault weapon. You do not have to, and the offeror does not have to prove or disprove and show it wasn't photoshopped. That will be the hearing issue. If you let it in, the other side will then have the opportunity before you to show photoshopping. But I'm not aware of any cases right now on that. I know on some listservs for evidence law professors are starting to banter that out. And we're looking for cases that now apply that, but nothing so far.
And I would just like to add, actually, before you move on, Professor, that our November topic goes into a little more about how to spot tampering with digital evidence. So, to the person who asked that question, I suggest you come back for our November topic where we delve a little more deeply into that.
That's terrific. And again, in that respect, I think then what you as hearing officers will now be looking at and see, gee, wait a minute, this doesn't smell right. You'll look at it and you'll see something's not, it's not right. Something is not right. So I think that's a very important and nice program as a supplement to what we're doing today. And I highly recommend it for your attendance. Okay, continuing, page 23. Social media messaging. Using now, instead of email, text messages, a lot of people now are using their social media page as doing everything, including messaging with people. And they are sending messages and they are receiving messages, acknowledging messages. And let's say that those messages now become relevant in your hearing. First thing, again, as I mentioned on page 23, prove the message. Prove the message. As I mentioned now in bullet point 3 on page 23, which should be bullet point 3, is boldfaced by mistake. This can be accomplished by a printout of the message. Again, if you have your printer handy, this can also be done by looking at the testimony of a witness who I logged on to that page. I saw that and testified to the contents. So again, it should not be much of a problem for establishing what those contents are. Where the issue will be now is, again, authentication. Authentication. It's basically the same rules, same circumstantial evidence rules we just talked about. It's very important, and we're going to be seeing this as we go along. On page 24, bullet point 2, I mentioned Judge Grimm. Judge Grimm now is the electronic evidence guru of the federal courts. He wrote the seminal decision, Lorraine, which I cite consistently, where he now spent about 120 pages talking about how you get in electronic evidence. He was fed up with lawyers who didn't know what the heck they were doing. So he spent a considerable amount of time laying it out. And one of the things he made sure of is simply saying that, gee, it says Hutter sent it. It's not enough. You need to show more to link the person you claim sent it to that page, to that message. Now, a lot of times, again, forensic proof becomes critical, but it's not always necessary. What it is now is, again, the same standard that we used before with authentication. Now, I use an example of that. On page 25, the best way of looking at that is I gave you the cite to a Vermont Supreme Court case in which the parties were trying to get in social media messaging. And the Vermont Supreme Court did what I would call a textbook discussion. Lawyers, this is what we want. And they point out several things. In my minor bullet points, bullet point II, same standard, authentication. And again, bullet point 3, is there sufficient evidence that you could find that the messages came from the person you claim it to be? In that case, Christina. And how do you do that? Look at, again, circumstantial evidence. And that now, again, on page 26, point B. A lot of this now will come from the contents. The person is setting it, talking about what I did last night and sending it to his or her best friend. Best friend then responds. The owner then responds as well. And they're talking about things that only he could have known about. That's classic authentication evidence. The unique words, phrases, the liberal use of emojis, maybe with sunglasses. Do they have a unique emoji? All that now is what we're looking at. And again, I give you a couple of instructive cases to give you an idea as to what you should be looking for in the application of those common sense rules. I especially like on page 27, the Colby 2 decision from the 3rd Department, ruling on the admissibility in a family court matter. And family court follows the rules of evidence, but pretty loose. Parental termination case. The respondent parent proffered Facebook messages to the subject child. She utilized her adult son's Facebook account. How were they properly authenticated? Proof that the respondent testified, I was present. I saw counsel print it out. It's the same documents that I saw. And it now confirms everything with other testimony in the case. It links up. That's, again, common sense. You do not have to prove beyond a reasonable doubt. Just enough from which you can say, I'll admit it. Now, whether I'm going to then trust it and credit it, I'm going to wait and see what the other side does. Maybe through cross-examination, maybe through their proof on their direct case. Hearsay, again, just like posts on a social media site, the key is going to be really the admissions exception. And I'll talk about some other exceptions as we go along, in which I have some actual cases. Rarely does the social media messaging create problems with hearsay, because inevitably they are going to be admitted, the contents, as the admission of the party who owns who sent the message. Okay, page 28. Emails. Now, I mentioned here the advent of email has in large measure, this is on page 28, made obsolete traditional means of communication. Letters. And when's the last time you wrote a letter? Probably eons ago. And now, what I understand from some tech people is that emails now have been supplanted by text messages. And text messages now are the way to go, almost making cell phone calls obsolete. But in any event, we still have emails. And we'll be talking about text messages separately. Again, the best way of looking at emails is to simply view them as a writing, just in a different medium. Now, what's interesting, a lot of times people will now say that I never received it. I really didn't send it. That can be shown to the contrary by looking at the person's computer. The computer now will be logging automatically the date something is received, the date something is sent. So that really should not be a problem if it ever comes up. Now, the authentication, page 28. Again, authenticate. Same standards as before. Now, what are those methods? Now we have a lot more case law, and I can delve into a little bit more deeply the factors that I pointed out before, because these are the factors being used in emails, but they'll be the same for social media posts and social media messaging. Now, one thing I mentioned at the top of page 29 in point B, that if someone now argues, Judge, you can't let that in, that email could be fraudulent. It's possible. Yeah, but that does not prevent it. That Safarian decision has clearly, it's cited a lot of other courts. No. Authenticate, that will get rid of the problem of possibility of alteration and fraud. And again, a great decision from the Eastern District of Brooklyn. This is bullet point C, the Lindy decision. And this kind of goes back to the photoshopping question that was raised. The authentication process does not require the proponent to disprove the possibility that a party or a non-party altered the email. That's not part of the laying the foundation process. Now, ideally, there'll be a witness with knowledge. I saw that person send it. But barring that, again, our old friend, circumstantial evidence. Also, this is bullet point 3 on page 29. The courts now are in complete agreement that merely because the sender box says mhut@albanylaw.eu does not establish that I sent it. Why? Because anyone could create an email address in my name. You go on, put Google, how to develop fraudulent email. You'll get some citations for articles. So you need something more. And the something more is what we're dealing with. Now, there is an exception, at least some courts are starting to think about it. if the email is, clearly that rule is applicable with personal emails. But if it's coming from a business, mhut@pepsico.com, some courts are starting to say, that, well, with a business, maybe that should be sufficient because they should be more careful and they maybe have better firewalls, some better software to prevent all this from happening. But don't count on it. Don't count on it.
Professor, there's a question in the
Okay.
Q&A box. It's related to this issue of fake emails. If a user's computer was taken over without their knowledge by a botnet, for example, turning it into a zombie computer to engage in illegal activity, and the computer owner is then prosecuted, is it possible to authenticate this as exculpatory evidence without forensics?
Be very difficult. That's the problem now with, again, these new techniques that are coming up. The used to be the spoofing, and now that technique. It's a difficult problem because the proponent now is going to say, wait a minute, I didn't send that. Well, it came from your computer. And the only way that you can really disprove that is by showing it didn't. And that's going to have to be a forensic person to show it was planted. I just finished reading a novel, by Michael Connelly, my favorite mystery author, in which a person set up someone else by sending to that person all sorts of child porn. And then made a tip, look at Hutter's website. It's all full of gross child porn. And he's prosecuted. Now, how do you prevent that? Difficult, until we now get some more countervailing measures. And it's simply going to have to be the forensic to disprove it. And again, that puts that person at a disadvantage. They're going to have to hire a IT person. And that can become expensive. But right now, I'm not aware of, and I explore the evidence professors on their listserv, explore to see what emerging technologies there are to handle that. But so far, nothing. It's a great question, a great question. So what are the circumstantial evidence? Here we have some better examples, but again, equally applicable to what we just saw before and later. But they do come up in the context of emails, but it's applicable universally. The contents reveal matters known only by the sender or a small group of persons. The chances that a third party would be aware of it are nil. We're a close-knit group. We keep this confidential. The address of the recipient is consistent with the email address on other emails sent by the same sender. Now, I did this example 2 weeks ago with the family court judges in New York City. But it should be aid for children attorneys in family court proceedings. They receive an email from respondent. Has email from respondent. How do you know it's respondent? The way you lay the foundation, I have dealt with that person before. I send emails to that email address. That person responds. I then send up a follow-up. That series of emails is consistent, the same address. So therefore, the likelihood that this other one is not his is questionable and enough to authenticate. You do not have to establish Fort Knox type security and show an absolute inability to forge. We don't have that yet. Not required. Even the voodoo judge has admitted we don't have to go that far. Distinctive characteristics. The Bleckman decision, Siddiqui, Rinson that I mentioned on page 30, bullet point C, again, is terrific in pointing out they use a certain font, in Arabic font 10 times Roman with some sort of acrylic. People like their unique thing, their modus operandi. That can link that person to that email. Emojis now are becoming ubiquitous. And again, people love their emojis. The reply letter one, D. This developed from an old New York Court of Appeals case. And it goes along with what I just mentioned. I sent an email to johndoe@aol.com. I've never dealt with that person. I believe that is his email address. I then receive a response. Responding to your email, here's my answer. And then gives all sorts of information that he would know about. That reply, that single email response would suffice. And suffice now that I had sent that email to him, to respondent. You know you're guilty as hell, don't you? And he responds, no, I'm not. But maybe I am. So that's another great technique. Subsequent conduct of the person showing awareness. The person all of a sudden changes their patterns of behavior after receiving this email. That may indicate I got the right address. Now also, and this is an interesting, okay, found on the sender's computer in the hard drive. Again, that gets into forensic proof. Now, I love number 5. This is important. Where did the person get the email? Again, where there's been discovery, and there's been a discovery demand, I want to see all emails in your company that concern X topic. And in response, you get a ton of emails. The mere act of production is enough to authenticate. You ask for things in their file, they send what's in their file. That was authentication. Now, yes, in administrative hearings, no discovery. But you may ask the person, where did you get that email? Well, we were trying to negotiate a settlement. Hutter provided it to me. That's enough too. So again, simply common sense ways to now show that this is what it purports to be. An email from the person you claim it to be. Now, another issue that is starting to be developed is the attachments. I put now on a Word, on my Outlook email, I'll attach now a PDF document. If I attach that PDF document, am I vouching for its authentication? Attached now is a letter I emailed to everyone, or I found in my file. Is that now authenticated? Because now I'm sending it as an attachment. At least one court, this is the Madison 1 case, 2009 decision, which says if you attach something, you've agreed that it's authentic. Who sends fraudulent attachments? Now, do you really vouch for attachments? I think the lesson there is be careful what you would attach. So more to be developed on that. And again, the only most recent case I found on that was a 2009 decision. Hearsay, same thing, truth, non-truth purposes. But now we can talk about a couple more exceptions. that again could be applicable to the other forms of digital evidence we've been talking about. First, with email chains, it may be authentic, but now that attachment is going to have to satisfy the hearsay rule, either in the sense of not coming in for the truth, or there's an exception. In that respect, I mentioned on the top of page 32, each email must be separately analyzed. The question here is, what if you attach a screenshot? Let me address that when I address specifically screenshots. That's an important question that the Court of Appeals has answered, and how to deal with screenshots. Because we have screenshots not just of text messages. We now have police officers, when they're at the scene of the crime, they'll ask the proprietor, do you have surveillance? Yes, let me see it. And they'll view the surveillance. Then they'll take screenshots of something that's very relevant to the crime going down. So screenshots are starting to loom large. And fortunately, we have a terrific decision by the Court of Appeals, recent, that addresses that. I will get to that later. Now, one of the things I would suggest to you, again, if you're an evidence junkie or you're curious, on page 32, bullet point B, Jeff Bellin, a fabulous law professor, teaches at William & Mary Law School. He has a great article on hearsay, addresses all the issues quite well. And Mr. Bellin will be the source of a unique rule that the legislature enacted with respect to the admissibility of digital imaging. So he's a good source. Now, the exceptions. Obviously, once you authenticate, the exception now is coming from the party opponent. Petitioner's putting in now, this is respondent's email, an admission. Absolute admission. No doubt about it. Now, again, this is what, when I preach this to attorneys, if you look at small double I, on page 32, under admissions, an email forwarded by a party opponent may constitute an adoptive admission of the email. How many times have you received an email and you forward it to someone, FYI? You now may unknowingly, unwittingly, be now admitting that that is your admission. That email that you forwarded, you've adopted it. Now, the evidence rules for adoption is, I have not made the statement, but I'm aware of it. I had the opportunity to deny it. I didn't deny it. And if it were really false, I would have denied it. It's adopted. Now, there's a great case, don't cite it here, but I'll just mention it, in the Court of Appeals a couple of years ago. Defendant now is in Rikers. He's been arrested, domestic violence, battered his girlfriend. He calls her, please visit me. So she goes to visit him. And she now lays into him, why did you do this to me? Look at what you did. Look at my scars. I have 3 broken ribs. Now, the visiting areas in Rikers said all conversations are being taped. What does he say? What about those Mets? Does not answer the question. And the Court of Appeals held People v. Vining, V-I-N-I-N-G. Court of Appeals held they've adopted it. If it was false, you certainly would have said, hell no. So that same teaching goes on now with forwarding emails. Be careful. Present sense impression. Now, this is the cousin of the excited utterance. We all know what an excited utterance is. Judge Kay's definition. Anything that starts with, oh my God, and ends with an exclamation point is admissible as an excited utterance exception. With present sense impression, a statement made by a declarant while observing an event or immediately thereafter is admissible. No need for it being exciting. Now, there needs to be some corroboration of the event, but this now becomes a wide open exception. And the way it's being used a lot now is illustrated by the Ferber case. An employee of Merrill Lynch is on the phone now with another person who now turns out to be the defendant. And that defendant is telling him all the bad things he's done. Now, the Merrill Lynch employee tells his supervisor, sends an email. I just got off the phone with defendant. He's a thief. He's a real scoundrel. Now, at trial, he doesn't remember anything. Is the email he sent describing the contents of his conversation with the defendant admissible? Now, what defendant said to the Merrill Lynch employee is an admission, but his transmission was viewed as a present sense impression. He made that email as soon as he got off the phone. So your notes of people's notes of conversations, they can be admitted as present sense impression. Now, we're also seeing on page 33, admissibility of businesses or of businesses, emails as a business record. Now, you might say, wait a minute, emails really are individual. However, there are emerging cases, and not all cases agree with this, that if the culture of the corporation is to deal everything and make everything an email, if it's a regular practice to confirm deals with emails, talk about matters, then it can qualify as a business record. Other courts are not so sure on that. So don't be surprised if you see someone trying to get an email in, not against a defendant, maybe made by a third party. And the only way you're going to be able to get that in, perhaps, will probably be the business record exception. Okay. Now, I mentioned that on page 34, point E, the double hearsay. That again would be the Ferber case. Okay, if we can jump over best evidence. Text messages now. As you know, text messages are nothing more than a written communication sent from one cell phone to another cell phone or some form of handheld device. Essentially, they're emails sent by cell phones, transmitted by the internet. Now, one thing to keep in mind, and maybe technology is starting to change this, but traditionally, while emails are backed up and kept by the server, the network owner, text messages are not. Text messages only exist on the sender or the recipient's cell phone. And that's going to be presenting some problems that will go through easily taken care of. especially now with use of screenshots. But my point is that with text messages, again, similar to emails, there may be a little issue with respect to best evidence. I'll get to that with screenshots. But it's the same damn proof or same way you do it. Circumstantial evidence. Distinctive characteristics, reply, chains, stuff like that. Now, with text messages, I want to go back. If you turn to in the beginning of my material with respect to rules of evidence, on page 8, if you jump back to page 8, there's a very important rule of evidence that many people are unaware of, what's called the rule of completeness. The rule of completeness. What did he say to you, officer? He said, I'm guilty as hell. Admitted. Now, defendant wants to show that in that same interview with the police officer said, yeah, I did it, but I did it because they had a gun to my head. Now, obviously, the prosecutor doesn't want to put that in. Can you put that in? Now, it's an out-of-court statement. Your client's not going to take the stand. Can't come in as an admission because you want to support for him. Admissions only cover against the party. This is where the rule of completeness comes into play. What it means now is if a part of a conversation, part of a transaction, part of a writing is introduced, and another part of that writing, transaction, or related conversation will show that the part admitted would be misleading unless you now consider this missing part, the complete part. And that gets you over hearsay. Now, I mention it now because the federal rule of evidence on rule of completeness was just amended to make it more compatible and actually more similar to New York's rule of completeness. And now lawyers all of a sudden are now becoming aware of New York's rule of completeness. This becomes important then with text messages. What do I mean by that? Well, text messages, you keep on scrolling, right? And that one text message will be, I'm going to go pick up the junk. And maybe junk is a code word for drugs. And then later on, in response, okay, go for it. And then the person says, well, of course, you know what I'm talking about with junk is really junk. 1-800-JUNK. Of course, it's not drugs. Now, if you let that one part in, I'm going to get junk. And that's slang now for drugs. To show that he really was not dealing in drugs, you need that other text message. So with rule of completeness now is you now have to let in that continuing series of text messages, especially when they are made over a short period of time, maybe over a day. So you can see the whole shebang. Now, importantly, with respect to that now, oops, I just lost my place. Excuse me for a minute.
All right, Professor Hutter, actually, seeing as we'll take that for a second, and I'm going to share my screen again with the code word. The code word is 24 here. That's 24 HEAR. Okay.
Okay, we're back on page 36. Again, not repeating the circumstantial evidence stuff that we dealt with on the other topics. But there are 4 great New York cases that I cite to you. The Pierre Clemenstein Aguadudo decision, and more recently, the Fourth Department decision in McCoy, all deal with now getting in these text messages. And they're textbook examples of laying the foundation that shows this text message had to come from the defendant. Why? He used, that's his name, his street name. Everyone refers to him like that in these text messages. He's talking about information that only he would know, especially when this guy, not the brightest, now talks about in a text message, I really messed her up. You should see what I did to her abdomen. Well, you can link that up. But those are good cases for you if you're thinking of, want to review a little bit more, understand this, to take a look at. And I just don't want to spend the time dealing with all those things all over again. But now, getting back to the question that was asked, on page 38, screenshots. We all now have our iPhone, and we're taking pictures with it. And we call those screenshots. And I'll take a screenshot of text messages, emails, you name it, photographs. Well, detectives, they'll take a screenshot now, series of screenshots, or just run the tape to film it of a part of the surveillance tape. How do you get screenshots in? This is the Rodriguez case that I mentioned on page 38. 2 years ago, the Court of Appeals came down with this decision. It's significant because it is a unanimous ruling by a court that, as you know, is notoriously split between liberals and conservative judges. Here, everyone agreed to the result in this case. What was this case about? Defendant was prosecuted for child abuse. He's a volleyball teacher, coach at a local high school, junior high, and it's alleged now that he was sexually abusing and had an illicit affair with a 9th grader. Now, how do they find out about that? The young girl is in her home with her boyfriend. The phone pings, and she said, oh, I gotta take this. She has a big smile on her face. So she's looking at it and smiling. And the boyfriend says, uh-oh, what's going on here? He grabs the phone. And what does he see? A text message from the coach, sexually explicit. Then he starts scrolling, continuing sexually explicit. That was great what you did last night. Stuff like that. He's a predator. So he says, what the hell's going on? She grabs the phone from him. He grabs it back. He then pulls out his phone and takes screenshots of all these text messages. And he takes them to the DA. In the meantime, the girlfriend disposes of her phone. So that when the DA comes to investigate, the phone's gone, but they have the screenshots. How do they get it in? 2 steps. First, the Court of Appeals says you treat a screenshot like any other photograph. Is it a fair and accurate representation of what you saw? And who can lay the foundation for that? The boyfriend. And then finally, at the time of the trial, the girlfriend now comes clean and says, yep, those are the text messages he's been sending to me. So we have authentication. But now, a little bit deeper. The screenshots now authenticated what the emails. But how do we know the emails came from him? Again, that's where the girlfriend came in. She said, those are the emails that I've been receiving. Those are the emails I've been sending. Personal knowledge. And then to boot, the DA indicated and showed that the screenshots themselves, the series of them, were basically self-authenticating. Everything pointed back to the defendant. So getting in these screenshots now is relatively easy. Now, yes, there is the danger of fraud, of photoshopping. Now, if the photoshopping is done sloppily, you can certainly say, wait a minute, I'm not going to let this in. It's clearly not, it's been forged, been photoshopped. It's a real sloppy job. But now when you get some pros, it's going to be difficult. Again, as I mentioned before, I don't want to repeat it again. This is what we've got to start looking at. That's going to be the open question that lawyers are going to be confronting and judges will be confronting, whether on the administrative side or in the regular civil or criminal courtroom. But Rodriguez is an important decision. Now, to the extent there was a best evidence issue raised by the parties, the Court of Appeals said, other arguments we find without merit. And again, because the best evidence would be the hard drive, long gone, oral testimony, everything is suffice. Okay, websites now on page 39. Now, I want to talk about websites. What I mean by that, a website maintained by Ford Motor, a website maintained by Olive Garden, a local branch of Olive Garden, or a government website. The Secretary of State of New York, the Board of Education, City of New York. They post information. Now, that information that's posted on websites, how do you get that information in? Well, again, as I mentioned on page 40, make sure that information is actually posted. And this is normally done by someone who typed in the URL, got that web page, and looked at it and said, oh, wow. And they then maybe make a copy of it. If they have a copier, they may take a screenshot if they have their iPhone. And if not, they can testify orally what they read. So again, not a problem. The key now is looking at the type of website. Is it a private website or a government website? Now, private websites on page 40. Again, websites are not self-authenticating. Just because it says Pepsi does not mean it's Pepsi's website. You must have some authentication. And generally, authentication of the website comes from the webmaster. That's our website. I maintain it. I watch it. I have exclusive control over it. I'll be aware if someone hacks into it. I remove material that's not supposed to be there. But that generally is the best way of doing it through the webmaster. Now, a lot of times it can be done maybe when that webmaster puts something up on that website. Now it's very harmful to the company. And they'll say, oh my God, we didn't put that on there. We never would have said that. That's the crown jewels. Well, how long was that up there? You didn't realize the crown jewels is up there? Yeah, right. Just as people say the dumbest things on their social media page, companies post a lot of information that turns out to be defeating of them, exposing, revealing trade secrets, for example. So with private websites, it's essentially, again, showing that this truly is the website of the company, subpoena the webmaster. Now, with government websites are not only in New York, but also elsewhere. Government websites are generally deemed to be self-authenticating. What do I mean by that? All I mean is you put in secretaryofstate.gov.ny, you get that web page, that website. It's the Secretary of State website. Now, the reason for that is that government agencies all have websites. They're maintaining them. They use them for emanating, distributing information. You always see, check our website. And they obviously have the obligation to keep it accurate. So if it's on a government website, it's going to come in. And as you can see from some of the examples that I give you, starting on page 41 onto page 42, all sorts of information on these government websites can come in. I mentioned print out official records, the website of the Securities and Exchange Commission, and even the Firehouse Restaurant Group. Records from government websites are considered admissible and self-authenticating. Not a problem. Not a problem. Now, with hearsay, again, we have the issues, truth, non-truth. And again, if you have a good glass of wine by you, maybe cheap wine even better, we can have some interesting discussion on trying to figure out truth or non-truth, especially now at 7:30 at night. Now, the other thing, and I'll get to this late in a few minutes, on page 43, number 4, there is a movement in New York that if you have information on a government website, you don't have to offer into evidence the printout from that government website. Mark it as an exhibit. What the judge can do, and you can do as official notice, is take notice of the information on a government website. Now remember, judicial notice is facts that are indisputable. Now that's an alternative. Now I'll talk a little bit more with judicial notice where I have some more information, but I just wanted to alert you to that point. Okay, computer records on page 44. A couple of things with computer records. Okay, the question now is, how about a website like Google Maps? We have a separate statute in New York that makes it easy to get satellite photos, the mapping in. I'll get to that separately. And hold me to it. But I have a separate section on that issue. A couple of things with computer records first. Remember the distinction, and the case law in New York recognizes it, and elsewhere. There are two forms of computer records. Computer stored records, documents, databases that contain the input of humans. We prepare our invoices, our receipt, but we now scan them and store them and destroy the paper copies. Those are computer stored records. Then you have computer generated records. Records that are created by the software, by computer, do not involve any human input other than the human input that triggers the process. Driving through a New York thruway overhang toll, you get your Easy Pass receipt. Shows you now past that on such and such date at such and such time. Your ATM receipt, you withdraw $300 from a ATM corner of 5th Avenue and 45th at a certain time. That's computer generated. But I do in my class. You pull over for speeding. Yes, officer, I clocked you at 85 miles an hour. What do you mean? My radar gun, and I'll show you, says 85. Your Honor, hearsay. But remember, generated by machines, it's not hearsay. That's the point now. And we'll see how that's treated differently by the case law. Now, it becomes important with respect to hearsay. And let me treat this kind of together with hearsay and authentication, but dealing first with computer generated records. My material now on 45 to 46. Computer generated records are easy to get in. First, not hearsay. It's not hearsay because it's generated by a machine. Hearsay are statements by a declarant. Declarant must be a person, so no hearsay problem. Authentication. The authentication now, you must authenticate the results. And the authentication is very simple. All you need to do is show that the computer software works. How do you show that? We've been using it for years, months. The mere use now establishes reliability. And then show it was properly employed. That's it. Now, keep in mind here, and this is significant, because the proponent easily gets this in. Now, if I want to show that that ATM did not work properly and skewed the results, that's going to be on me to do it. So, especially in criminal cases, there are a lot of concerns here. But the New York courts very easily let in computer-generated records, so long as the technology has been in use for a while. Now, with computer-stored records, and then the printout, I now have my invoice. I want to show what I sold that day. That's all now fed into the computer. My salesperson fills out the invoice, the receipt, gives it to the data processor, it's scanned, and it's then stored. If I want all the sales information for September 24th for my widgets, I'll press a button, and spits out the widget information. How does that come in? Well, since it's initially formulated by hand, and initially you created a business record, you need to lay a foundation, the business record foundation. This is how we keep our records. Regular practice now to make records, make this entry. And we make that entry soon as we complete the transaction. And then show that the information then was printed out. The printout now is a copy, satisfies best evidence. Now, how do we know the scanning was proper? Well, scanning works. So the only real problem now here is to make sure that the foundation, the creation of that computer stored record, was up to snuff. And that's our traditional business record exception that you're all familiar with. Now, one thing I will mention specifically on page 49, dealing with medical records. Now, I'm sure you have, maybe some of you, you'll have be admitting medical records, so they'll be offered into evidence. Years ago, before Obamacare, the hospital record, the physician office records were all paper. And physician office records, hospital records, qualify as business records. But now, by reason of Obamacare, remember the attending physician or the attending nurse would carry around the chart of each one of his or her patients, and they write entries. And those entries then would be scanned into the hospital computer. Now, because of Obamacare, all the healthcare professionals have handheld devices in which they take their little pencil and write in on the screen of their device, press the button, and it's immediately sent to computer storage. And then it's printed out. So you got to account for that. And then the other thing, how many of you heard the mention of the term audit trail? Audit trail. This is page 50. Another fascinating aspect of Obamacare. An audit trail consists of the metadata of the computerization of the medical records. So when the physician is writing in with their script pen on a screen, that then is automatically transmitted, that now contains what we call metadata, which shows, in fact, when the item was created, who created it. And the Obamacare requires that that information be kept in the form of an audit trail. Now, ordinarily, when they produce the records at a hearing nowadays or a trial, it will be the printout of the scanned copy. But lawyers being lawyers, they say, oh no, wait a minute, that stinks. Something's wrong. We want to see the audit trail. We think that the records have been doctored, and the audit trail would show otherwise. And there's a big hubbubaloo in practice now again about the discovery of the audit trails. What must you need to get those in? Now, I mentioned that there's a great New York case on Gilbert on page 50, where Judge Doyle from Western New York goes through it and tells you all you need to know about that. Now, page 51, digital imaging. I now go on to Google. I put in the map, my address, 80 New Scotland Avenue. And I'll get an overhead shot of the map showing 80 New Scotland, the law school address, the adjacent streets, the hospital across the way. I now can press digital satellite. I get a photograph of that scene. How do I get that photograph in? Now, let me give you a little background on this. This is from on page 51. This is the Toronto decision, 5 lines from the bottom, from the Ninth Circuit. An issue was whether or not, when Border Patrol arrested the defendant, was he in Arizona or was he still in Mexico? He says, I was still in Mexico. The Border Patrol says he was in the United States. How do they prove it? Well, they took a Google satellite image of that location, and there was a unique landmark, a rock formation. And the Border Patrol said, I arrested him right at that rock formation. And then with the Google imaging, they print out the longitude and latitude. And guess what? He was in Arizona. Is that admissible? The Ninth Circuit said yes. And what the New York legislature did, and I have this on page 52, number 4, they enacted CPLR 4532B. And what it provides then is your imaging web mapping services, whether it is a digital with a printout of distance, satellite map, because we deem Google and similar web mapping services to be reliable. Judges may take judicial notice of the information that's on that satellite map. Mileage. If it says 52 miles from point X to Y, 52 miles. You can take judicial notice of it. Why? Google is reliable. I always say, gee, yeah, I follow Google Maps. A lot of people follow Google Maps. They'll get their home safely. Sometimes they'll end up in the Hudson River. It's not always accurate. But the legislature now swears by the reliability. And it means now it comes in, but if the other side has the opportunity to rebut it. No, that's not accurate. It's going to be difficult to do that. Now, all that accompanying information, latitude, longitude, time it was taken, that's automatically printed. And it's not hearsay. So the whole shebang comes in. It's incredible. It is really significant. Now, the basis for this was Professor Bellin's article, the top of page 52 in bullet point 3. That he found that his analysis of everything is, you know what, Google really works. Now, what's going further is Google. You can get their imaging, maybe what it looks like today or yesterday. Google also stores in its archives what that intersection looked like 5, 10 years ago. And you can access, lawyers can access those stored archives by what we call the Wayback Machine, which I mentioned in my material. So if I claim now there was a defect, and that defect now has never been fixed, and the defect existed in 2016, hearsay shot now shows it still existing. And I can show it never was fixed. by now going back year by year to show that the same defect is there by Google imaging. So this is a remarkable development that allows attorneys a lot of room to use Google stuff. And, we would never think about this a couple of years ago with developments in technology. I can't imagine what the next thing is going to be. Again, just don't even mention AI, the problems that's going to be creating. That's a topic for another time. So that 4539 is an important, very important evidentiary rule, which I believe statutory, I believe you're bound to follow it, even in administrative proceeding. Now, lastly, a couple of things with judicial notice. And judicial notice now from websites or whatever. You remember from judicial notice, a judge may take judicial notice in a civil case of facts that are indisputable. No reasonable person could dispute this. And indisputability can be shown one of two ways. Universally known, Albany is the capital of state of New York. New York City is known as the Big Apple. Or there's a source that says X. The temperature that you must boil water to eliminate bacteria, to cooked meat to eliminate bacteria. All that medical information, technical information. Common people don't know it, but there's a textbook. We can take judicial notice of that. Now, the problem is, what if that's from hard copies? What if the information is on a website? Dr. MD, Johns Hopkins, Mayo Clinic.com, where you can put in all sorts of information about a disease, what its symptoms are. Can I take judicial notice of what those websites say? The courts now are saying yes. All that needs to be shown is that the website is generally deemed to be reliable. And obviously, the more popular, notorious, the Mayo Clinic website. Have you got the big Montefiore Hospital in New York City? They're only going to put information out there that's accurate. We can take judicial notice of it. But when you start dumbing down the source, are you going to take judicial notice of something at Wikipedia? I doubt it. Now, the same thing goes on along with government websites. And that's why I now mention on page 56, bullet point 2, all these decisions from New York judges. I love the DiMatteo decision, custody dispute. Father wants custody of the child of the marriage. Why? Because the wife is now living with someone. Nothing wrong with that. They're divorced. But the new boyfriend smokes constantly and smokes in the home. The father believes that's unsafe for the child, who's 2 years old. So he wants to show that secondhand smoke is dangerous to children 2 years or younger. Now that sounds like a medical issue, doesn't it? I want a doctor to come in and testify to that, an expert. But what the judge did in this case is he went to the Surgeon General's website, and the Surgeon General had up studies that showed secondhand smoke is dangerous to children. And he took judicial notice of it. So those are the different things that you can do. Judge Shankman, the former presiding judge of the Second Department, there's an issue with whether or not the corporation, what was its principal place of business in New York? He took judicial notice of the principal place of business that was listed in the Secretary of State website. Again, the government's not going to publish wrong information. So those matters with judicial notice, again, become important. Now, again, it's options until the Court of Appeals says otherwise. Information on websites can be admitted through the website page or judicial notice. But the one thing, caution, if you're now writing up your decision and your findings of fact, and you're rereading the testimony, wait a minute, something's wrong. That doesn't ring true. Doesn't make sense. So you decide to do a little Googling of information yourself. And you find information now that really undercuts the testimony. And that testimony, the undercutting, is done by a reputable source. Can you use it? Well, this is the question that New York courts have confronted. And they've confronted a lot. And this is now on page 58, where the courts now are essentially allowing judges to check matters on the internet. Now, again, it looks like they're fact-finding, but bear with me for a minute. And this is a subject to a lot of dispute. Judge Marlowe, the former judge in the Second Department, now retired, wrote a great article that I cite on page 58. Do we really want judges Googling? Well, judges will go beyond the parties' briefs. Why not now look at other facts? So far, what we have now is we'll allow you to do it, but before you take judicial notice, you got to tell the other side. You must tell the other side. This came up in a great case. It's mentioned in Judge Marlowe's material. Well, I forget his name. It's in the Second Department now. They'll come to me. He's trying an insurance fraud case. The plaintiff, who's now claiming that it was a defendant insurance company, intentionally set, puts on an arson expert. He runs through his methodology. Judge now takes it under advisement, closes proof. He has some second thoughts now about this methodology. So he goes to the website of the association that the expert said. I'm a member in good standing of the Association of Arson Experts. So he goes on that, new developments. He clicks that link. New development says, don't ever rely upon this methodology. It's unreliable. Guess what? That was the reliability the expert uses. So the judge then says, goes back to the parties. Wait a minute. I want you now to answer this. And went to the company now, the lawyer who called that expert. I want an explanation. Did he act wrong? No. Now, obviously, you can't now do research to solve the other person's case. That gets to be a close line. So I'll leave that for another discussion. Okay. Yeah, one of the attendees talked about taking notice may make the decision seem less reliable to many. I think what you should do is when you take judicial notice, make a record and say, I'm taking judicial notice of the Johns Hopkins website or even WebMD. A lot of courts have taken judicial notice of WebMD, maybe by pointing out now that other courts have done it. Other court, you may say, I've taken judicial notice because it's certainly deemed reliable. And again, make the record. That makes it a little bit more legitimate. Okay, my time is pretty much up. Any other questions? I got a couple more minutes. We got all your CLE credit time taken care of. Any other questions you have?
So,
And again, I would say, again, I obviously don't want to get involved with cases that you're dealing with. But if you ever have questions regarding electronic evidence and you want to just shoot the bull with me, maybe just talk generally, you have my email information. Send me an email. I love talking this stuff, especially with experienced people like you.
thank you so
Okay,
much. So while people are thinking of their final questions, I just want to say before we run out of time, thank you so much, Professor. This was very interesting. I appreciated how you applied the traditional rules of evidence to the modern digital world that we're all navigating here today. And many of the examples that you gave are really relevant to a lot of the issues that our ALJs and hearing
good.
officers are dealing with. So thank you so much. I did have a comment on taking judicial notice of WebMD. Every time I've used it, it always told me that I have cancer. No matter what the symptoms, it always ends up with cancer. So
Oh,
I'm a little concerned about that trend. But that being said, thank you, Professor. Thank you for our attendees. Thank you for those of you that had comments and questions that you posted in the Q&A box. It contributed to making the discussion feel relevant tonight. I will say that our next program is Thursday, October 10th, also from 6 to 8 p.m. by it's called the Roberts Court, and it's a summary of some of the big blockbuster cases from the most recent Supreme Court calendar. It's put on by John Barquette. He's done this program for us before. It's always a good time if you're interested in Supreme Court cases, which many of us are. And with that, I think we can stop recording, Lisa. And
I would just like to remind everyone to please fill out their CLE forms and email them in to me by 8 p.m. tomorrow night.